On this episode of Law Weekly, we talk more about some of the issues thrown up by the judgment of the Presidential Election Petition Tribunal, and especially the implications on the Electoral Act. We have the views of a senior advocate of Nigeria, Robert Emukoro. Also showing on the program, recently retired Justice of the Supreme Court, Justice Amina Algi, seeks urgent amendment of the Constitution to strengthen the judiciary. Plus our weekly recap of the top trending stories from the courtrooms. Hello and welcome to the program. I'm Shola Shuyeli. There's a need for electoral jurisprudence consistency, as well as a change of mindset among INEC staff workers, the judiciary, politicians, and even the electorate. These are the views of Senior Advocate of Nigeria, Robert Emukoro, who is the managing partner at Summit Law Chambers. With a flair for reducing complex legal issues into simple, easily digestible nuggets, the senior advocate served on the Electoral Act Committee of the National Assembly, which saw to the enactment of the much-celebrated Electoral Act 2022. He was also the lead consultant to the Senate Ad hoc Committee on the alteration of the 1999 Constitution that produced 44 far-reaching proposals for the alteration to the 1999 Constitution, some of which were signed into law by the immediate past president, Muhammadu Buhari. In this interview, we talk about the implications of the Presidential Election Tribunal judgment on the Electoral Act. But first, I started by asking my guest his comments on the judgment without prejudice to the notice of appeal already filed by the parties.
Well, I must speak frankly that it will be very, very difficult to comment on the judgment that is an appeal before the Supreme Court without actually prejudicing making maybe prejudicial comments that may not be very palatable. But what I can say generally is that the judgment has given a direction of the thinking of the Court of Appeal in respect of all the issues that were ventilated before that court and which they ultimately resolved. Now, whatever they decided there for now should be taken as the position of the Court of Appeal, and hopefully maybe the Court of Appeal will be consistent in sticking to those positions they have taken. Because the single biggest problem I think we are facing in our electoral jurisprudence is inconsistency. There are so many conflicting judgments on the same issue, to the point where it is really very difficult for any lawyer to reasonably say that this is the law on this particular point. So let us take, for example, and this is without commenting on the merit or demerits of the judgment of the Court of Appeal, the issue of, I would say, qualification on the ground of membership, or on any ground that is intimately woven up with the issue of pre-election. They made a definitive pronouncement on that look, anything that has to do with membership is purely an internal affair of the political party. I think this has been the general understanding of lawyers that, look, anything that has to do with whether somebody is or is not a member of a party should not be the subject matter of litigation. The next points I want to just also comment about broadly, without necessarily saying what is right or what is wrong, but I think it's going to be a very significant issue. That is in relation to whether evidence acquired after the filing of the petition is available to the petitioner or indeed respondent for the purposes of proof of the petition. You know what was very significant in the judgment of the Court of Appeal was that the witness statements of very, very many witnesses was struck out, discountenanced on the ground that they were not filed along with the petition itself, suggesting that at the time you are filing your petition, or at any rate within the 21 days that you have to file your petition, you have to gather all the evidence you are going to use and file them. Any evidence you don't file at that material time cannot even be shut out for all time. I think that's one of the very, very important things that the Supreme Court will need to look very closely at. I think the Supreme Court needs to take a step back and really look critically at that issue. Not just on the bare bones of the law itself, but they need to look at it generally. What kind of impact that kind of decision will have on the democratic process itself. And of course, the other side of that too is also a need for there to be very, very keen consideration of this requirement of oral evidence. And if you look at Section 137 that says, look, it won't be necessary for you to call oral evidence where the originals or certified true copies manifestly shows non-compliance. The whole idea is that if from the document you are looking at, the very things you are complaining of, they are manifest on it, exactly why do you want to rely on oral evidence? And this is also relevant to the issue of the time it takes to resolve electoral disputes. One of the ways by which this time can be drastically cut is to make electoral litigation entirely documents-only litigation. Now, when you look at even the Electoral Act itself, I think maybe it's at Section 75, between Section 70 and 77 anyway, it provides that the entire electoral process shall be recorded in forms prescribed by INEC, starting from the polling unit right up to the point of final declaration. So which means the entire process is documentary. There's no aspect of this electoral process that INEC has not prescribed it, right down to the envelope in which you keep the used electoral materials. Everything is documented. Why this insistence on oral evidence? You must call polling unit agents. You are challenging 170,000 polling units. You want to call 170,000 witnesses for what? To say what? To say what is not in the document? The documents are there. So these are some of the issues that I think will be agitated before the Supreme Court.
There's a lot to unpack from all that you've said, and I know that some of these issues are still sub judice. But one thing I found interesting was what you said about all the processes of INEC being documented. Because what we saw with some of the election petitions was that INEC still objected, to the admissibility of some of the documents that came from this custody. And this has made many people, rightly so, say that the burden of proof placed on the petitioner is perhaps too high, and that there is a need to tweak the act to compel INEC to readily make documents available. I know that you did a considerable amount of work on the enactment of this Electoral Act, with the National Assembly. So do you agree that there's a need for a further tweaking of the act, or what reforms do you see?
Well, I think the points you have raised on the issue of the enormity of the burden placed on the petitioner really derives from what is presently Section 135 of the Electoral Act, for Section 139 before, which says that no election is liable to be invalidated by reason of non-compliance alone, unless the court or tribunal is satisfied that the election was not conducted in accordance with the principles of the Act and the non-compliance complained of substantially affected the results of the election. Now, the courts have consistently, that will be the Supreme Court, held that that whole burden is on the petitioner. Right now in Nigeria, litigation has become an integral part of the electoral process, because the way INEC conducts the election is just that people are dissatisfied and they now have recourse to the courts to try and seek relief or remedy. But in that process, I don't think the burden should be too heavy on the petitioner. Because if the burden on the petitioner is not too heavy, I'm not saying it should be light, but it shouldn't be too heavy. That is the only thing that will conduce to a freer and fair election. The elections should be getting better. But if things are seen to have been manifestly done wrong and the petitioner is unable to succeed, what it means is that our election will just be degrading at every point in time. I suppose that is part of the reason why you will hear politicians boldly declaring, go to court. It's like, what will happen? Nothing can happen to us. You go to court. So how do we really want to improve our electoral process, our democracy, if it is so difficult, almost impossible for a petition to succeed? So we need to ask ourselves that critical question. Do we want to improve democratically, or do we just want to be regressing? Honestly speaking, after 2015, there was a lot of commendation for INEC with the deployment of the card reader. I mean, everybody said that this election looked okay. I thought going forward, every electoral cycle there will be marked improvement. But frankly, I mean, this 2023 left so much acrimony. There's so much, and it shouldn't be so. Every election should not lead to so much acrimony. We need to address that. People should feel, okay, there are some problems here and there, but I think this election is okay. I will accept it, and we move on.
So how do we move on? This process of making INEC a respondent in the elections, where they now come to justify what they've done, is a major part of the problem.
I agree with you completely. INEC, I mean, I think it should be something that should be seriously discussed as part of our electoral reform. INEC shouldn't be a respondent. You know, every time we say INEC should be impartial, INEC should be impartial, but the moment you make INEC a respondent to defend the petition, exactly what you want INEC to do. They are going to defend the petition. So I think there's a need to look closely at that requirement that INEC should be. INEC should be an impartial stakeholder that is just in that proceedings to supply evidence. So I think there is still some room for reform of the Electoral Act, but I think the single biggest reform is the reform in the minds and the hearts of those who are charged with managing our electoral process, which is INEC, the staff themselves. If their mindset is to subvert the electoral process for a mess of porridge, there's no reform we are going to do in that Electoral Act that is going to, they will subvert it. And unfortunately, I have to say the same thing for the judiciary. If those who are sitting as judges, do not sit up and face the facts and the law and allow any irrelevant considerations to enter their deliberation, then what is the point of the reform?
I hear what you say about the reform of the minds of INEC staff and even the judges, but these gaps that you've identified in the Electoral Act, how do we reform the process going forward?
I think within the context of the specific provisions of the Electoral Act, I would think Section 64, subsection 4, that talks of collation. I don't want to speak about transmission generally because, frankly, I don't really think that transmission of election results in and of itself should be a big issue or should be a basis for you to void any election unless you are questioning the process that led up to that result. Whether the result was transmitted or... I don't see much in that. But within the context of Section 64, sub 4, which makes collation of any results, either from the polling unit or the ward result, subject to verification and confirmation, with one, the result transmitted from the polling unit, two, the number of accredited transmitted. If you look at that subsection, it uses that word transmission as the basis for verification and confirmation for the purposes of collation.
That's Section 64.
Section 64, subsection 4. Okay. It talks about you shall not collate, no power to collate, subject to verification and confirmation of the correctness of the result with what was transmitted. So when you want to talk about transmitted results, you need to talk about it within the context of this provision, not just abstractly. You have to show that if these results had been subjected to verification in accordance with this, then it should have been shown not to be correct and ought not to have been collated. That is the case you can make with regard to transmission, not transmission alone. They didn't transmit. So what?
Thanks for staying tuned. Newly retired Justice of the Supreme Court, Justice Amina Algi, has been speaking about some of the reforms she would like to see in the judiciary. Amongst other things, she wants the National Assembly to amend the Constitution to guarantee the improved functioning of courts across the country. She said this and more at the valedictory session held to mark her exit from the Supreme Court after a legal career spanning 45 years.
On the 7th day of November 2016, I achieved the pinnacle of my legal career when I was elevated to the esteemed position of the Justice of the Supreme Court of Nigeria. I was only the sixth woman to attain this distinction in over 50 years of its existence, walking in the footsteps of Honorable Justice Mariam Aluma Mukhtar, GCON, who first shattered the glass ceiling and later became the first female Chief Justice of Nigeria, and others who followed her. Initially, the shoes felt oversized, but I slowly grew into them. Now, as I bid farewell, my hope, actually my prayer, is that those that come after me will not face the same challenging situations which made it so difficult for those of us before them to fully rise to the occasion. When it comes to the Supreme Court, the age-old saying that the higher you go, the cooler it becomes is turned on its head. I have had the privilege of serving as a Chief Magistrate, High Court Judge, and a Justice of the Court of Appeal, yet I can confidently say that nowhere in these three lower courts did I encounter the level of heat I have ever experienced in this court. The heat is not about the weather, but the sheer magnitude of the workload. I even turned to an online thesaurus for words to capture the essence of this workload, and I quote, but I'm sure all my colleagues here, well, they are no more my colleagues, my former colleagues, will every word I will call, they will say it 1,000 times. Burdensome, difficult, grievous, harsh, intolerable, laborious, onerous, oppressive, hard, severe, tedious, vexatious, and wearisome. Each of these words accurately encapsulate the demands we face daily. Sometimes we sit all day. All the SANs here, they can attest to that, but they leave early. So other lawyers can say sometimes we're here from 9 a.m. till 6 p.m. A Supreme Court. Even customary court and area courts do not sit like that. This is the Supreme Court, and we are here all day, And then we have to take appeals that do not align with the court's role as a policy-making court. So something must change. That's what my speech is all about. Something just has to change. Something must give. We cannot continue this way. I have left them, but they cannot continue this way. This court is the apex court, and its final decision shapes society's social order. Justices should be able to focus on what truly matters. They could issue directives for formulating specific policies or amend existing ones to better serve their intended purposes. But how can they do that when they are drowning in an overwhelming caseload? The only way forward, as highlighted by the Honorable Chief Justice of Nigeria, Honorable Justice Olukayode Ariwola, GCON, during the special session last year marking the commencement of the 2022-2023 legal year, is to amend the Constitution to restrict the circumstances under which appeals can reach this court. Like I said earlier, this marks the final instance where my voice will be heard in any court. And I wish to use this opportunity to directly address the 10th National Assembly through the distinguished Senate President, Senator Godswill Akpabio, who was once my student at the law school, Nigerian Law School. I had the privilege of teaching him evidence, and I trust that he learned it well. Hence, it should be evident to him that swift action is needed from the 10th National Assembly to accomplish what the others could not. That is, amending the Constitution to enhance the functioning of our courts in Nigeria. It is said that a teacher's reward is in heaven. I cannot wait to reach heaven to receive my reward for teaching him, because it is my sincere wish that the justices coming behind me do not go through what those before them went through. Thus, I implore the National Assembly to undertake the necessary constitutional amendments. By doing so, this court and its justices can be freed from the constraints that impede their ability to fulfill their mandate of upholding the rule of law, justice, and democracy.
And just before we go, let's quickly do a recap of some of the top trending stories from the courtroom.
We begin with the report that the Kano State Governorship Election Petition Tribunal has nullified the victory of Governor Abba Yusuf of the NNPP and instead declared the candidate of the All Progressives Congress as the winner of the March 18th election. In its judgment, the three-member panel chaired by Justice Oluyemi Osadebe ordered INEC to withdraw the certificate of return from Governor Yusuf and issue same to Mr. Nasiru Gawuna of the APC. The judgment was delivered virtually via Zoom, with only 50 individuals permitted inside the courtroom. The tribunal invalidated 165,663 votes accrued to Governor Yusuf, citing unstamped or unsigned ballot papers as a reason for declaring them invalid. The governor and his party have, however, vowed to challenge the verdict. From Kano, we move to Bauchi State, where the victory of Governor Bala Mohammed in the March 18th governorship election has been upheld by the Election Petition Tribunal sitting in the state. The tribunal dismissed the petition filed by the governorship candidate of the All Progressives Congress, retired Air Marshal Sadiq Abubakar, citing his failure to prove the petition beyond reasonable doubt. The chairman of a tribunal, Justice Polycarp Kwaha, specifically held that the petitioners failed to prove their allegations of non-compliance with the Electoral Act, electoral irregularities, as well as the alleged bypass of the bimodal voter accreditation system BVAS machines in some polling units in 10 local government areas. And in a similar manner, the Enugu State Governorship Election Petition Tribunal has upheld the election of Governor Peter Mbah of the People's Democratic Party as a winner of the March 18th election. The Labour Party candidate, Chijioke Edeoga, had approached the tribunal to challenge the declaration on the grounds that Mr. Mbah was not qualified to stand for the election because he allegedly forged his NYC certificate. The petition also cited cases of overvoting in 3 local government areas. The tribunal, chaired by Justice Kudirat Akowo, dismissed all the grounds of the petition, stating that NYC certificate is not a requirement for contesting for the office of a governor, and there's nowhere that the NYC certificate was attached to the documents which Governor Mbah submitted to INEC by the respondent. On the issue of wrong computation of results, the panel said the petitioners failed to prove this case, and the witnesses they called gave the same testimonies for different polling units and wards, despite the fact that they are all in different local governments. Away from the states, the presidential candidate of the Labour Party, Mr. Peter Obi, has filed his notice of appeal before the Supreme Court seeking the nullification of a judgment of the Presidential Election Petition Court and the election of President Bola Tinubu. In the notice, which contains 51 grounds of appeal, Mr. Obi says the court erred in law and thereby reached a wrong conclusion when it dismissed the petition he lodged to challenge the outcome of the election. He maintains that the 5-member panel of tribunal led by Justice Haruna Samani carried out a miscarriage of justice against him when it held that he did not specify polling units where irregularities occurred during the election. He further faulted the court for dismissing his case on the premise that he did not specify the figures of votes or scores that were allegedly suppressed or inflated in favor of President Tinubu and the ruling All Progressives Congress. And just like his LP counterpart, the presidential candidate of the People's Democratic Party, Mr. Atiku Abubakar, has also filed his notice of appeal at the Supreme Court, seeking the nullification of the judgment of the Presidential Election Petition Court. In the notice of appeal predicated on 35 grounds, Mr. Atiku insists that the tribunal committed grave error and miscarriage of justice in its findings and conclusion. The presidential candidate maintains that the tribunal erred in law when it failed to nullify the presidential election held on February the 25th, 2023, on the grounds of non-compliance with Electoral Act 2022, when by evidence before the tribunal, INEC conducted the election based on grave and gross misinterpretation, contrary to the principles of the Electoral Act based on the doctrine of legitimate expectation.
And that's the program for today. If you missed any part of it, you can find it on past episodes on our YouTube channel. Do also give us feedback via any of our social media platforms. I'm Shola Shieli. Thank you for watching and see you next week.